Hello, my name is Dorota Puskowicz.
Hello, my name is Agnieszka Siewieńska.
We are attorneys with almost 20 years of experience working in Polish and international law firms, and now we also both co-manage the Polish office of Peterka & Partners. Agnieszka, why don't you say a few words about our law firm?
Naturally, Peterka & Partners is a regional integrated law firm that operates in Central and Eastern Europe. We provide legal and tax services to businesses. In addition to Poland, we have offices in the Czech Republic, Slovakia, Hungary, Bulgaria, Romania, Croatia, Ukraine. In a few weeks, we will have another office in Slovenia.
Yes, and we think that a major advantage of working at an international regional law firm is the fact that we perform a lot of cross-border international projects and transactions, and we thought that we could use this advantage to create a series of podcasts on specific legal issues from the point of view of comparative legal analysis. We will talk about them by not only referring to Polish law, but also to jurisdictions where our law firms operate. First, since both of us have always been involved in M&A transactions, we are co-leaders of the M&A practice group at our law firm. We will begin by discussing M&A transactions in our region, and that is M&A transactions in Central and Eastern Europe. And before we discuss M&A transaction differences in each country, we'll begin with what's common and talk about a typical M&A transaction right here in our region within Central and Eastern Europe. Agnieszka, are there any similarities, or each country is governed by its own laws? What does it look like? What kind of model do we have?
At the outset, I'd say that in jurisdictions where our offices operate, there are more similarities than differences. All of these jurisdictions have adopted the Anglo-Saxon model in terms of how transactions are conducted, also in terms of transactional documentation. Even though we're here and we operate within continental law, we actually use documentation that is largely modeled on the Anglo-Saxon documentation.
And this is standardized.
Definitely. If we're talking about transactions involving foreign entities, about cross-border transactions, the process itself is also very standardized. Let's go briefly through the various stages of this process. Usually, parties to a potential transaction start with a non-disclosure agreement. In this agreement, the parties agree to keep any confidential information obtained from each other as secret, and typically they oblige themselves to keep the mere fact of negotiating the sale of a given target as secret. The next step in the process is to negotiate the basic terms of the sales contract, such as price, payment terms, conditions precedent, scope of representations, and warranties. If the parties come to an agreement on these basic terms of sale, they sign another document. It could be a letter of intent or a term sheet. This document will define basic terms of the contract and basic terms of the process itself. Then comes a rather time-consuming stage of the entire process. That is, buyer conducts various types of due diligence. This usually means legal, financial, and tax due diligence. All business issues are also investigated. It usually takes a few weeks, and parties tend to simultaneously begin negotiating share purchase agreement, which is very standardized again. Dorota, maybe you could list most common elements of share purchase agreement.
Yes, of course. So the share purchase agreement is indeed a standard document based on the Anglo-Saxon model, and it contains the same elements, meaning the price adjustment mechanism, payment method, obligations of the parties, potential interim period, conditions precedent, non-compete clause, closing. And we have a concept that is lifted directly from this Anglo-Saxon model, that is the concept of representations and warranties. This is the part where lawyers who already operate under a given jurisdiction must determine how to specify this liability to make it compliant with the law of a given country. Even under Polish law, we have different concepts regarding this liability, whether it's more of a guarantee or a statutory warranty for defects of a sold item. It's interesting to note that in Slovakia, for example, it's considered that it is always a statutory warranty. So it means that a violation of these representations and warranties implies a defect of the sold item. It's an issue to consider because even though this concept is based on the Anglo-Saxon model, it needs to be implemented well into the governing law so that there's no doubt whether it is a risk-based liability or a fault-based liability. After concluding SPA, we need to deal with fulfillment of conditions precedent. Then comes the transaction closing and registration activities. And everywhere in the EU, we need to deal with registration of the beneficial owner. And we always have to keep in mind that in all our countries, we must always check if the transaction is subject to reporting to the antitrust authority, whether it's necessary to obtain such approval either at the EU level or at the national level. But this issue will be subject to a separate podcast. What is more, within the EU, we also have a concept of controlling foreign investments. Its framework has been established by the EU in regulation from 2019. So each EU country has its own separate regulations for an additional approval for acquisition of shares or stock by entities from countries outside of EU, EEA and OECD. An interesting fact is that Bulgaria has introduced this recently in March 2024. But I also think this is a topic for a separate podcast.
I agree. Since we've discussed the standard process and common elements, we will move on to differences present in individual jurisdictions in which Peterka partners operate.
Yes, and we will begin with Poland because this is jurisdiction which is the closest to us and we are the most active in it. So our experience is that foreign investors are often puzzled by certain regulations in Poland. They aren't familiar with them. Is it something? It's something completely new. Am I right?
That's exactly right. Poland is a country with some differences, also some additional requirements concerning the need to report transactions. Also, the need to investigate certain aspects in the context of obtaining potential approvals from administrative bodies. Let me begin with an issue connected to real estate. The issue of whether the target owns real estate and what kind of property it is one of the most important issues to explore in due diligence because it can have significant consequences for the transaction structure and cause the need of obtaining special approvals from relevant administrative bodies in Poland. If we conclude that the target owns real property and the buyer of the shares comes from outside the European Economic Area or Switzerland, then we always have to consider whether we need an approval from the Minister of the Interior and Administration. On the other hand, if our target owns agricultural property with an area of over 5 hectares, whether as a single property or as several properties that together have an area of over 5 hectares, then we must always examine whether there's a potential right of first refusal or the so-called right of acquisition vested in the so-called National Support Center for Agriculture. This can determine the entire transaction structure because a conditional agreement is necessary when dealing with the latter.
And what our investors find strange is that the right of first refusal is vested in relation to the shares and not the property, right? The company may have a large factory located elsewhere. It just happens to own agricultural property, then theoretically all shares in this company are subject to the right of first refusal. We are not saying that this is often used, but it's a restriction that determines the manner in which this transaction is carried out, right?
Exactly right. If we conclude that we're dealing with the right of first refusal or the right of acquisition of the National Support Center for Agriculture, then yes. And in such case, we are obliged to enter into a certain type of agreement and to undergo a certain administrative procedure. Another novelty and difference for Poland that always surprises foreign investors is tax related to the transfer of shares or stocks. Because in Poland we have a tax called tax on civil law transactions in the amount of 1% of the market value of a given shares or stocks. This is something that may not be avoided, and this tax always encumbers the buyer of the shares. Another novelty and difference that surprises foreign investors a lot is the new tax that was recently introduced. This obligation applies to real estate companies. That is, companies whose assets are largely made up of real estate or rights to real estate located in Poland. These properties, of course, must also have a certain value for the company to qualify it as a real estate company. So if we conclude that we're dealing with such a real estate company, if we determine that the transaction involves a seller who is not a tax resident in Poland, and if the seller sells a certain portion of shares, at least 5%, the target will be obliged to collect and pay as a remitter advance income tax on the sale of shares in the company. It's very surprising to foreign investors. This is our experience. So that would be it for Poland. Dorota, are there equally interesting differences or curiosities in the Czech Republic?
Not really. We even asked our Czech colleagues, but their legislator doesn't think that real estate is something that deserves special protection. So in principle, there are no restrictions there, no need to obtain special approvals for acquisition of shares in companies that own real estate, whether commercial or agricultural. Likewise, there is no civil law transaction or transfer tax there. Naturally, we should always investigate if the target operates in a special sector like banking, insurance, or telecommunications, like everywhere. Then we have to investigate whether we need approval from a regulator or administrative body. Regarding taxes, we have to remember that if the seller holds shares continuously for 5 years, then they are to some degree subject to income tax exemptions up to certain thresholds. So these thresholds need to be checked, but other than that, we found no special differences. Naturally, foreign investment control in case of investors outside the EU applies here as well. Tell me, Agnieszka, it's typically thought that Slovakia is a market that's very similar to the Czech Republic, that these legal systems are actually the same. Is this really the case, or are there any differences in Slovakia?
The system is similar, but not identical, because Slovakia has its own separate legislation. The transaction model itself and transaction documentation are very similar. In Slovakia, as in the Czech Republic, there's no tax that encumbers the buyer or seller. That's similar to our tax on civil law transactions. However, there's one very important issue that differentiates Slovakia from Poland and the Czech Republic, and it's very relevant for transactions since they are often carried out using SPVs. That is, companies that are specifically set up or bought for the transaction purposes. These SPVs are very often limited liability companies.
And they usually have one owner, right?
Yes, that's right. And a very important point to remember when talking about transactions involving a limited liability company in Slovakia is that the chaining ban applies during the entire period of the company's operation in Slovakia. So it's different than in Poland. Because in Poland and in the Czech Republic, the chaining ban applies and at the company's foundation stage. It's impossible to have a transaction where a single person limited liability company buys all shares in another limited liability company. This is very important when talking about the transaction structure itself. I think it's the most important thing as far as Slovakia is concerned. You already mentioned liability for representations and warranties earlier.
Yes. As I said, in Slovakia, this liability is based on the principle of statutory warranty, and we should keep this in mind when preparing the SPA.
That's right. So that would be it for Slovakia. We may move on to the next country, Bulgaria. Dorota, do you have any highlights regarding transactions there?
In Bulgaria, from a practical point of view, there are important differences regarding form in which SPA can be concluded. So I would say that this form is the closest to the Polish notarial deed. That is, it's not enough to certify signatures under the agreement, but the notary also certifies the text of the agreement. So this comes with the consequence that such an agreement can only be signed before a Bulgarian notary. What follows is that the power of attorney to enter into such an agreement can be only executed before a Bulgarian notary. And in our practice, it often happens that advocates, legal representatives, or managers receive a power of attorney certified by a foreign notary, and they make transactions on its basis in Poland, the Czech Republic, or Slovakia. In Bulgaria, this is impossible unless such a power of attorney is signed at the consulate or embassy according to specific principles. It's something to keep in mind. Another difference is that the transfer of share ownership does not take effect at the time of signing the SPA, like in Poland. but at the time of registration in the commercial registers. So it's delayed a bit, and which means that this period of uncertainty is a little longer. This may involve the need to regulate somehow this interim period before registration, as only then the buyer becomes the formal owner of the company. Okay, let's move to Romania. Agnieszka, is there anything special there that foreign investors should pay attention to when planning transactions?
Of course, there are some interesting differences. Before I move on to them, I would like to mention that Romania is nowadays very popular with foreign investors. We do a lot of transactions there. So the first difference is the same as in Bulgaria, meaning that share ownership is transferred at the time of registration of the buyer in the commercial register. Another important issue is the special taxation of the sale of shares in companies that own real estate located outside city limits. Before I talk about the details, I'll say that there are general restrictions for companies in Romania when it comes to acquiring real property outside city limits. In order to acquire such property, the company must meet certain minimum conditions, such as existence and registration in Romania for at least 5 years. Only then, and after meeting some other conditions, the company may own property located outside the city limits. So if the transaction involves a company based in Romania that owns property outside city limits, if these properties have a certain value, meaning if their value accounts for at least 25% of all assets, and if time since the company acquired these properties hasn't exceeded 8 years, then the share seller must pay a special tax, which amounts to 80% of the difference between the value of this land, of these properties, at the time of their acquisition and their value at the time of the sale of the shares. So it might be a high tax, and it might be important to foreign investors. So these are the most important differences for Romania. Let's move on to Hungary.
In Hungary, we have something similar to the Polish tax on civil law transactions or transfer tax, but it's charged only in the case of transactions on shares in real estate companies. We deal with this tax when a majority stake is acquired, amounting to at least 75% in a company that owns property in Hungary, and whose properties represent at least 75% of the value of the company's total assets. So if these two conditions are met, then we are dealing with transfer tax. So there are certain thresholds for this tax, and it can amount to 4 or 2%. It's another thing to keep in mind when buying a real estate company. Another highlight is that representation by a lawyer is compulsory when registering transactions in the commercial register, so all corporate documents must be drawn up and brought by a lawyer to the court for the transaction to be registered at all. Our last country is Croatia, our youngest office. Tell us, Agnieszka, is there anything? And I know that there is at least one interesting issue, because this year we coordinated this transaction from Poland. It was a transaction selling a company on the UK market. The company owned shares in Polish, Hungarian, and Croatian companies. And regarding Croatia, neither the buyer nor the seller was aware of a certain regulation, and this delayed the entire transaction. Agnieszka, can you please explain this?
Yes, it's an interesting issue that's related to Croatia. and its adoption of the euro. Foreign investors are very surprised that in order to record any change regarding a company in the commercial register, like for instance a change of the shareholder, they must amend the company's articles of association so that its share capital is no longer given in Croatian kuna but in euro. The articles of association of the target must be amended, and this must be registered either before or in the course of any other change concerning that company in the register. This is very important because amendment and registration may take even few weeks. So investors need to take this into account when planning transaction timing and structure. There's another interesting fact from the point of view of foreign, also Polish investors, because there are many companies that invest in real estate in Croatia nowadays. These are apartments, but this can also be land. These investors must be aware of the fact that in Croatia there's a very extensive system of first refusal rights that applies to agricultural properties. It also applies to shares in companies that own agricultural real properties. Obviously, there are limitations that need to be carefully analyzed so that the transaction is valid at all. What's interesting is also that we need to notify the Croatian National Bank about investments made by foreign investors. And by foreign investors, within the meaning of Croatian law, are also meant investors from the European Union. So we have a duty to notify the bank within a certain time after the transaction about the fact of making the investment of the transaction itself. Croatia was our last office located in the European Union. Our law firm also has an office in Ukraine, which operates continuously despite the war and also conducts transactions there.
Yes, when it comes to our office in Ukraine, we are of course very proud of it, that despite the war, despite the very harsh conditions, it's doing great and it's fully operational. When it comes to M&A transactions, the Anglo-Saxon pattern has taken hold here as well. Differences, if any, are not so crucial. For example, we have to deal with the need to amend the company's articles of association to register a new shareholder. If there is more than one shareholder, then there is the preemptive right to the purchase of shares by existing shareholders. There is also a similar problem to the one in Bulgaria, as some registry courts refuse to register transactions made on the basis of the documents drawn up before a non-Ukrainian notary. Some of these courts state that the documents or signatures on documents must be certified by Ukrainian notaries. So for safety, it is usually recommended to do it either on the basis of a power of attorney in Ukraine or just directly in Ukraine by persons representing the companies. Besides that, Ukraine is not an EU member state. It's not subject to the foreign investment control regime established within the European Union. But Ukraine has also introduced a number of war-related regulations intended to mainly combat investments made in Ukraine by individuals and companies from Russia. There are some specific regulations on these issues. I think that's it.
Yes, that's it for today. Thank you for listening to this episode, and please join us for the next one.